being shortly after, it being shortly after 9:30, we will begin our hearings for today. First one is House Bill 75, and because the prime sponsor has a conflicting meeting, we will ask the good senator to introduce 75.
Mr. Chairman, introducing House Bill 75, an act increasing the threshold of county-owned personal property subject to competitive bidding.
And seeing no questions, we'll go right to the list. Kate?
Thank you, Mr. Chair. Kate Horgan, New Hampshire Association of Counties. This is a very simple bill. It updates the competitive bidding threshold for county-owned personal property from $300 to $3,000. The last time this particular statute was updated was in the late 1990s. As you might imagine, inflation has grown dramatically in that time, so we're just trying to bring that up to reflect a more accurate number for counties who are sending things out to competitive bid. I'm happy to take any questions.
Are there any questions? Senator?
Thank you. I only have one question, and that is that the letter you just handed out says that the statute was updated in the 1990s. The testimony that was submitted on behalf of the sponsor, a little letter here, says it was updated in 1959.
That was the original bill put in, but it has been tweaked. I don't know what those tweaks were, but the last time it was tweaked, this particular statute was touched according to the New Hampshire RSA's is 1990s. But the threshold could have been 300 in the 1950s.
All right, thank you.
Yep.
All right. Just for the public that may be listening to us, there is an amendment for House Bill 83, which affects this bill because it will take the language of SB 75, 87, and 83 and combine it all together. That bill is the next one up, and we'll open that hearing in just a minute when we get to the time. So let's go to the statute. Because the prime sponsor has other commitments, we'll ask the senator to introduce the bill.
Mr. Chairman, introducing House Bill 83, an act relative to County Commissioners' Authority on County Buildings.
There is an amendment on this bill. The amendment number is 2023 1066S. In effect, it combines this bill with a couple of others. We have one person on the list to speak. Kate? Hi there.
Thank you, Mr. Chair. Again, Kate Horgan for the New Hampshire Association of Counties. We do support House Bill 83, and this simply increases the threshold for the county commissioners to repair, enlarge, or erect county buildings from $5,000 to $25,000. This statute hasn't been updated since the mid-'80s. And Senator Gray did hand me a copy of the amendment, and the association has no problem with the amendment.
Questions from the committee members? Seeing none, thank you very much. Seeing no one else that wants to testify, we'll close the hearing and we'll open the next hearing in just a minute.
I wonder how long these things are going to be hanging around.
The air purifiers?
We'll be in here in,
Till they break.
yeah, 5 or 6 years, 10 years from now.
Till they
they'll be
break.
rattling around.
Well, usually when they come in, they turn them on high, and then when people come in, they turn them on low. All right, it being the appointed time, we will open the hearing on House Bill 87. And because the prime sponsor has another commitment, we'll ask the good senator to introduce the bill.
Mr. Chairman, introducing House Bill 87, relative to county responsibility for capital building projects.
All right, thank you. And we have one person signed up to testify. Kate?
Should have just stayed here.
It would have been fine with me, Kate.
Good morning again, Mr. Chairman. Kate Horgan, New Hampshire Association of Counties. This is a very simple bill as well. It simply cleans up the language as to what powers are vested within the county delegation, and it also mirrors the language in House Bill 83, allowing commissioners to spend up to $25,000 on county
had two.
buildings. Happy to take any questions.
Are there any questions from the committee members? For the listening public, as I've announced in the last two hearings, there is an amendment which affects this bill, and that is Amendment to 2023-1066S on House Bill 83. It actually takes this bill and puts it into House Bill 83 along with House Bill 75, and we will deal with that when we exec the bill. Seeing no one else to testify, we'll close the public hearing and wait for the appointed hour, and we will take up the next bill.
Thank you, Mr. Chair. Yes, it's probably going to take me longer to drive to and from Spofford, New Hampshire than to even talk about this bill, but, whenever possible. Yeah, hope so. Whenever possible, I do feel it's important for the sponsor to be here, but it is a busy time, so it is difficult for sponsors to always attend. This is another very simple bill. All it does is amend RSA 202A:15 concerning the qualifications and the tenure for library directors. The 202:15 currently reads, "The librarian," meaning the director of the library, "shall be appointed by the Board of Library Trustees for a term of office agreed to at the time of employment and until a successor is appointed and qualified." My bill simply takes out the last phrase, "and until a successor is appointed and qualified." I was asked to do this by my constituents because I live in a very small community, Spofford, New Hampshire. We do have our own library, but it's small. And we have had, over the past 5 years, we have had 3 different library directors for various reasons. And in between, it's just impossible for a small community to find somebody to stay or to fill in until a new librarian director can be found. And so this RSA has been incredibly difficult for us to comply with. So we always have a contract with our library directors. We don't plan to just willy-nilly toss them to the winds or anything like that. We do plan to keep them according to their contract. We would not renege on that. But when they do leave, it's difficult for us to find an interim, and sometimes they just cannot stay until a new person is found. So this was kind of a workaround. When I testified on this bill in the House, it was supported by the New Hampshire Library Trustees Association as well as the state librarian. And if you have any questions, I'd be happy to answer them. Hopefully you have one, sir.
I certainly do. This language is pretty much standard language in a lot of the appointments that we do. And there was a name that we always used at the shipyard, Charlie Finaris, okay? So whenever you had an example, you always used Charlie Finaris. So right now, there would be nothing in the statute that says you can't take Charlie Finaris off the street and say, you're going to be the library trustee or the librarian for a day. And then that takes care of all the other stuff that you had with your previous librarian.
And we tried that. We actually offered positions to other people and were turned down for various reasons, one of which we couldn't pay. We're just a very small community, and we just couldn't pay the price that the people were asking for. But yes, we tried that and said, just step in. And sometimes, because it's a small community, it's not just a day that we need a fill-in. We've gone as long as a year to try till we could find a person that, as this RSA says, has the depth and breadth of knowledge to run the library. So if we were thinking that we could just ask somebody to fill in for a day or two, that would be great. But we have gone for as long as over a year. And we're not willing, even though we're small, we're not willing to back down on our qualifications for a library director. We have high standards in Chesterfield. And so we want to keep those standards. And so it has been difficult sometimes for us to find the right person.
So if I took the words that you've crossed out, and in between may and until, I put in, between and until, I put in may serve in there, don't I do the same thing? And,
I'm sorry, I just lost the bill. Hold on.
Got one right over on the table for
Okay,
you.
I've got it here. So you're suggesting that it says the librarian shall be appointed by the Board of Directors for a term of office agreed to at the time of appointment, and
May serve.
I'm I think that would serve. My original, this is an amendment. My original bill said or until a successor is appointed and qualified. The House Committee, as well as New Hampshire Library Trustees and the State Librarian, did not like that word or. And so they asked for the amendment where it was just ended with after the word employment.
So you don't have any problem with that modification?
Agreed to at the time of employment.
You can tell them to come yell at me.
Okay. I'm sorry, sir. Could you repeat how you want to say it one more time? Until at the time of employment.
Between the and until, in the section you've crossed out, all that's going to stay, and it would say, and may serve until the successor is appointed and qualified.
As long as everybody understands the definition of may means doesn't have to serve until a successor is found. Yeah. Yes.
That,
Yeah.
I wouldn't put shall in there.
Right. Right.
Any other questions from any of the other senators? All right, seeing none, thank you very much.
And-
Seeing no one else here.
Can I didn't look on my calendar, so excuse me for asking a silly question. When do you plan to exec the bill?
Depends on how things go today. It could be as early as today. It could be a month from now.
Okay. I'll just keep watching.
It depends on these 4 other people that are sitting with me.
That's okay. I'll just keep watching. Thank you very
All right,
much.
thank you now. So we'll close the hearing on that, and I'll entertain a motion to go into executive session.
So moved.
We have a motion and a second. Motion made by Senator Murphy, seconded by Senator Susie to go into executive session. All those in favor say aye. Aye. All those opposed, we are in executive session. We have 4 bills that we need to deal with today. And we will start right at the top of the list, 221. And property tax exemption. Is there anybody that wants to talk before I take a motion?
Thank you, Mr. Chairman. I have a problem. Am I permitted to use an iPad? Bills, this is the one provided to me by the state.
You can use a regular iPad in here.
Thank you.
We're not on the Senate floor, so.
Right. So, Mr. Chair, I think SB 221 is a good local option. I think we heard that in the hearing. There are some organizations that we would expect to be exempt from local property tax that are surprisingly not. So I think it serves a purpose for cities and towns that do not wish to adopt this. They do not need to, but in places where we are struggling to find a workforce, childcare is essential to us parents being at our jobs, and so I think this is a measure that's become necessary, and I would support us passing it.
Senator Apples, I think I saw your hand first.
Thank you, Mr. Chairman. And this is just a question. Would this tax credit apply to only the landlord? What would happen in situations where the child care or daycare is renting the space or leasing the space?
If you know the answer, I'll take it from you.
Well, I was just going to say, I think in the hearing, what we heard is that essentially, either the property tax could be on the leasehold estate, which is normally assessed as a separate parcel, or, the tenant would expect that the savings would be passed by the landlord onto the tenant through the lease. A lot of leases they have the tenant pay the property tax.
Wasn't there a section in here that said that if the exemption only applied to a particular portion of the property, but I don't think that it did in that section talk about the owner of the property, so that if an organization say the YMCA
Yep.
was offering daycare, they could apply for it for a portion of that property if they were providing daycare, but they would not be able to apply for the whole thing. And I don't remember any provision in here that would allow the YMCA, if they were leasing that land out to someone, to apply for the provision. If anybody reads it differently than that, I certainly would be interested. Senator Murphy, you had your hand up.
Thank you, Mr. Chairman. So there's two reasons why I can't vote for the bill. And one is that I think it's fundamentally unfair. I generally oppose property tax exemptions, carving out certain benefits for certain groups of people or certain kinds of businesses. I certainly share the goal of lowering the cost of childcare. I have children myself. I know it's expensive. But grocery stores feed people. It's very essential. But no one's going to say we should be granting property tax exemptions to grocery stores. When you lower taxes for some people, you're going to raise them for everyone else. The other reason is that it's not effective. I mean, it would ostensibly lower the cost a little bit, but there's much more effective things we could do to lower the cost of childcare. The legislature caps the number of children that can be seen by every staff member in every facility. We could raise those caps, and that would be a lot more effective than this. I run restaurants, and if there was a law that said you can't have more than 10 tables in a restaurant, the costs are fixed, the rent, utilities, the cost of labor, insurance. I would have to raise the menu prices on those 10 tables to cover the cost of those expenses. And that's what happens in these facilities. We cap the number of kids that can be in each facility and per staff member, and they have to raise the cost of childcare to cover those expenses. So if we want to seriously approach this issue, I would suggest raising the caps, or in other ways making it easier and less expensive. But this is not a way I can support.
Senator Abbas.
Thank you, Mr. Chairman. One issue with the property tax exemption is, my daughter goes to daycare, and I see Massachusetts license plates. There's nothing wrong with that. But the point is that the tax exemption is being paid for by the town, but the children at the daycare are not necessarily residents of the community. There's also people that live in Pelham or they live in Windham, same thing. And for whatever reason they choose the daycare. I know when my son's preschool was closed for a school vacation, we sent him to a childcare place in Windham, and we don't live in that town. So that's my point is the equitable benefit here may not necessarily, like the community taxpayer, I think, is paying now for children who don't live in the town as well. So I have some concerns with that. But I think the goal of the bill is good. If we can help lower the cost, we should try to figure that out. But I don't know if this is the direction. I would think we could talk about those ideas at a different time. But
Mr. Chair, if I may, just to provide some counterpoints for conversation. Senator Murphy, I understand your argument, and respectfully, I think the caps are set based on safety standards, but it's certainly something I would also be open to addressing. I think, like housing, there's probably not one answer to this question, but in fact multiple. It's easier to have a busy waitress than to have kids who need help and don't have someone to attend to them. But I think in addition, Senator Abbas, there could be parents who work in Salem, and that's why they're bringing their kids to daycare in Salem. And so in the end, Salem may benefit from having childcare more readily available because it contributes to their workforce. So I certainly understand the arguments. I just wanted to provide a counterpoint. And again, this is an option. It certainly shifts taxes from one party to another. There's no denying that. But local property tax exemptions are a policy choice. And so I know when I was on city council in Portsmouth, we chose to do some exemptions for veterans, for some assets of the elderly, and those are policy choices that I think are just best made locally. Thank you.
Okay. So in the discussion, I've heard three motions possible out of the discussion. Senator Abbas, you've got your mic turned on like you want to speak.
You began your sentence before my mic was on. I'm just going to call you out.
Well, that's okay.
Thank you, Mr. Chairman. I'll make the motion of inexpedient to legislate.
So we have a motion of ITL. Further discussion? All those in favor of ITL say aye.
Aye.
Opposed?
Post.
3-2. Senator Abbas, you get to take that one up. Next bill is 224, Senate Bill 224. And 224, we didn't mention the amendment on the other, but since the motion was ITL, I didn't get there. The amendment on this one is 0789. Discussion before I take the motion?
Mr. Chair, just to present the amendment, the intention was to address some concern about the language raised, at least by some of the parties outside this room, just to try to state in more plain language the intention of the bill, which is that if a municipality were to take advantage of this tool, if this bill were to pass, that the municipalities in adopting any new zoning standards would need to sort of do an analysis to factor in the economics of exercising this tool to ensure that we are being realistic in our housing development.
Okay. Did all of you get an email from Mr. Ben Frost? If you didn't, I did. And his email basically said, I believe that ELMA committee will exec 224 tomorrow. Inclusionary zoning, housing opportunity zones. Talking about our earlier conversation, and he is saying that if the bill were re-referred, that he would enjoy working with whomever to do something with the bill, not to influence you, but if personally, I again look at this one like the last bill that we just did. It makes it tough to do different things, and I can see that this one could be litigated quite a bit with the things that would happen in a planning board meeting. But further conversations from anyone?
If I could, Mr. Chairman, I do
Yeah.
think that, certainly the original bill on page 1, starting that paragraph on line 19, I do think it's relevant to update some of that language, including the income level from the median income, and then also the percentage, because in this case, it actually would reduce the percentage of units constructed that have to be designated as low income. So I think the bill makes some important necessary changes, and I think it would be a shame if we weren't able to move forward.
So you would be suggesting a committee amendment which did what?
I wasn't. I was saying that the language of the original bill coupled with the amendment, but that the original bill language in the second paragraph, I think, is worthy of passage. So, I'm sorry. I think that second paragraph beginning on line 19 is worthy of updating. As the senator from Portsmouth said earlier, there's no silver bullet for fixing affordable housing and the lack of affordable housing in this state. So I think we do have to look at various ways to approach this issue, this problem that seems to be pervasive throughout our state. And I do think that those changes in particular are something that we should still consider.
Senator Perkins Cook, I'm going to let you comment on that because that would take out your amendment and modify your original bill.
Yeah, thank you, Chair. I am open to continuing to work past this session on the language in Section 1. If the committee is open to passing Section 2, you know, I would support a committee amendment to do that. And I also understand if there's still concerns about the language in Section 1 to continue to work on that with the parties involved. So I think it's an important concept, so re-refer would certainly make it easier for me to work on than ITL.
Further discussion? I think I just heard a motion from Senator Perkins Cook to re-refer. Do I have a second? All right.
I know. Well,
Seconded by Senator Susi. Further discussion? All those in favor of re-refer, say aye.
Aye.
All those opposed? The ayes have it. Do we have a motion to go on consent?
So moved.
We have a motion to go on consent. All those in favor of consent calendar, say aye. Aye. Opposed? And Senator Perkins Cook,
yes, I'll take it out.
you get to take it out.
Senator Schuster.
I'll second.
I wasn't worried about it, I guess. Since we all voted for it. Yes. No,
It's an important question, and Trish would be asking that question of you later, so.
Did we pick someone to take 221 out?
Yes, Senator Abbas.
Okay.
221 was Senator Abbas. 224 is you.
Yep.
271
Yep.
is the next one on the list. 271, an act relative to seating delegates to the National Party Convention.
So,
Discussion before we take a motion.
yes, please, Mr. Chairman. This bill, in its current form, I think is problematic for a couple reasons. Most notably, there's actually a U.S. Supreme Court case dealing with states' rights in a primary versus seating of delegates at a party convention. The case is Cousins versus Wagoda. And
How do you spell
so the
Wagoda?
last name is Wigoda.
And the Cousins common spelling?
Yep, Cousins, common spelling. But essentially what happened is it was the convention, it happened to be Democratic National Convention that was happening in Florida, and there was a question about the seating of delegates and the way they were slated. And from Chicago, there was an appeal to the Credentials Committee of the party. And there were several, I mean, there's a lot of legal analysis leading up to it because there was a district court action, court of appeals, there was an injunction, there were a number of measures, but ultimately the Supreme Court said that the convention serves the pervasive national interest of the selection of candidates for national office, and that this national interest is greater than any interest of an individual state. The paramount necessity for effectiveness of performance of the convention's task is underscored, and it goes on. But I think the point is that I know we have a bunch of stuff trying to, make sure that we ensure our first in the nation primary. This does nothing to benefit our primary. In 2008, we had a similar situation, and it was the Republican National Committee, and no one brought forth legislation at this time. So the legislation doesn't seek to do anything that it could effectively do. And I just don't see the need for it. I think it's actually probably more detrimental to move it ahead. It will have no impact whatsoever on the seating of national delegates. So, you know, as certainly a person who has gone to the mat for preserving the primary and will continue to do so, and I believe our law is in play, I see no need for this legislation. I don't think it's helpful, Mr. Chairman.
Senator Abbas.
Thank you, Mr. Chairman. I am not familiar with the Supreme Court case, but if I could ask a question, in that case, was a state law or being challenged, and that gave the court the, and was that law somewhat similar to what we're trying to do here?
The law was regarding the selection of delegates, and as I said, overall, the court said no, the party has the presiding interest. I mean, I think they're two separate issues. I think the issue is what we in New Hampshire do to host our primary, and the party's determination is different in that it's the seating of delegates for the purpose of nomination to a party. You know, we have a state-run primary. We will continue to have a state-run primary. There have been issues along the way over the years about how delegates are seated at the convention, but an individual state can't tell the national party that has its call, that has its procedures, how it's going to seat delegates. And they're two separate issues. And I think we're conflating the two, and I think the legislation, as I said, will not in any way be impactful, because the party is going to make a determination. But the determination of how delegates are selected or how many delegates there are doesn't in any way impinge upon our law and our ability to hold our primary.
Senator Murphy.
Thank you. I'll throw in my 2 cents. You know, the DNC has said they're not going to seat their delegates. And that's ultimately up to them.
Just,
I would agree with you.
if I could just clarify that they haven't made a final determination of seating of delegates. There's a potential for sanctions.
They've threatened to not seat the
They did.
delegates.
They did, you're correct.
And so, and they've demanded that we change our state law regarding the primary date. And we're clearly not going to do that.
Correct.
And I think the whole point of the bill is to essentially say, we're not going to do that. In fact, we're going to double down on it. I would agree with you so far as to say that there's no teeth to it. There'll be no consequence for them. They won't see the delegates, assuming that they follow through on the threat. They don't see the delegates. What happens? Nothing. So it's more a statement of no. But we've seen a lot of that, right? I mean, we've seen numerous bills, including your constitutional amendment, saying that no, we're not going to play ball.
If I could, I mean, I think the constitutional amendment is a separate question, because in that case, we are talking about state law. We're talking about putting state law into our Constitution. In this case, I actually think it could be detrimental, because as I said, the National Party has not made a determination yet, and, you know,
Okay.
I can't tell you what the ultimate resolve is going to be. You are correct, Senator, that a threat was made, but there are ongoing discussions about, you know,
You'll
I
be
think
much
it's
more familiar with that stuff than I would
really
be.
hard for the National Party to say not a single delegate from New Hampshire is seated, including our members of Congress.
Yeah.
You know, and that, so I think ultimately there will be delegates seated. How that gets sorted out, we'll know over time, but this in no way, you know,
Affects it.
has merit or could actually not be helpful to that process, so.
I understand the point.
Senator Abbott.
Thank you, Mr. Chairman. Taking the political parties out of this and just trying to speak in general terms, because it can happen in the future to another political party. Let's just, the delegates is supposed to represent the will of the people. And if you have a party that, although it's just a threat this time, I would say under such circumstances would ignore the will of the people, at least not follow it. what do we do to protect the people here? Do we just say, well, there's nothing we can do? I don't, maybe if this isn't the answer, what is the answer? Because the way I'm looking at it is you have the potential for our state, although it's a party that I'm not a member of, but members of that party are the people who support, the candidate for that political party not really having, they're kind of being excluded from the process. And that part of that is offensive. Now, does this solve that problem? Maybe not enough, but I don't want anyone in this state to feel like they're not part of the process. So the concern I have is, does this make a statement? Does it solve it? According to my friend from Manchester, perhaps not. But I think we got to do something, right?
Well, speaking of that, I think I just heard from Senator Abbas a motion ought to pass. Is that correct?
On 271?
On 271.
I may have said that. I'll make a motion about to pass.
Do I have a second? I will second it. Further discussion? All those in favor say aye. Aye? Opposed?
No.
Opposed.
3-2. And I will take that one out. Because I can. On that one, certainly forward along to me and to the Senate attorney, the citation, Cousins versus, and we'll have a chance to look at that before it comes to the Senate floor. Okay, CACR 9. Senator Abbas.
I'd like to move ought to pass.
We have a motion of ought to pass on CACR 9.
Second.
And we have a second. Senator Murphy, discussion.
If I may, Mr. Chairman, I would just reiterate the testimony I provided to the committee, but ultimately what inspired me to put this in was when you're hearing that there'll be a penalty if we don't change our state law, and I'm looking at that, again, that can 10 years from now, the roles will be reversed, and I wouldn't put it past another candidate for president of the United States to potentially do such a thing. And what I'm looking at is the pressure to change our state law, and if we don't, there's a penalty. And I don't think that that's the right thing, because this is a tradition of our state. The first in the nation primary has become a tradition. There's a sign, by the State House, in honor of the tradition. It's been something that's been supported by Republicans, Democrats, independents. It's literally puts us on the map as one of our traditions, and for us to change that, I find to be the only reason why they want to change, because we showed how awesome it is. We've also, it's benefited being in a smaller state. We get our results that night, or sometimes early in the morning, but our results are done very fast. We've shown by example. It's a lot of responsibility having 20 candidates on the ballot. Some states like being at the back of the line because there's only a few candidates still running. But we take that responsibility. We take it with pride. A candidate can tour this entire state without a war chest of funding because it's a smaller state, and you've seen candidates effectively campaign and do exceptionally well on both sides of the aisle. But by putting this in the Constitution, this tradition, the right's now going to the people. So you can put all the pressure you want on the politicians. We should give this to the people, because it's a tradition that the people have celebrated in the state for 100 years now, and should continue to celebrate. And this is the next step to making that opportunity. It also protects it as much as we can at the state level. If anyone who says, I want to protect our First Nation primary, this is the best way for us to protect it. It's taking it a step further. And I think by putting it there, this tradition will forever be a tradition of the state. And for that reason, I hope you join me in supporting the ought to pass.
Further discussion? Senator Murphy.
I just want to reiterate one thing, and that's, I have the experience of having lived in other states. I lived in Maryland until I was 29. And Maryland's a state of 6 million people. I never saw presidential candidates, ever. I mean, once in a while you'd see the plane fly, Air Force One fly over the city of Baltimore where I lived, and since I lived here, what, going on 20 years now, I've met all of them. I've met all the candidates. And in a small state like this, the advantage is they get to meet real people with real experience who can vet them, ask them tough questions. When you have a presidential candidate standing in your living room and you get to know them, it's a job interview. And it's a job interview in a way that can never be pulled off by a state like South Carolina. It's too big. They'll never be as good at it as we are because of our small size. So I wholeheartedly endorse the amendment.
Further discussion?
I just echo all the things said about the primary. The one thing I would say regarding, I don't know that it's needed, but I will support it. There's no question that, we've said this before, there's one thing both parties can agree on, it's that we have the first primary. And I've stood at the national convention, at the national party, and said the same thing, and will continue to defend it. There's no question about it. I think the thing that we have to understand is that they're two different roles, the national party versus what the state does. And the national party didn't give us the primary. We created the primary. We were the first state in the nation to actually say it should be an open popular vote. It should be run by the state. Anybody who fills out a form and has a filing fee can run. So I just, I have a concern. They can't take away something that they never gave us to begin with. So I just want to put that on the record that New Hampshire is first, will be first. I will support this, but I think our placement is clear no matter what.
Seeing no other discussion, all those in favor of vote to pass, say aye. Aye. Opposed? And we will not put that on consent. And
Good, Senator
Senator
Abbas.
Abbas? Gets to take that one out. All right, we heard several bills today.
Nothing ready
The
for
last
prime
bill
time.
that we heard was 72,
Anything ready for-
and you guys were actually all here for that one. I was uncomfortable taking out the words in line 5 on page 1 of the bill, because that is pretty much in every one of the appointments that we do, that the person, and some people are interpreting that they have to serve, okay? And I've never interpreted that they have to serve, that if they are there, they have the ability to serve, that their appointments didn't. And I suggested, instead of taking out those words in between the may and until in that sentence, we put in, I mean, the and and until, we put in may serve, okay? Which I think, makes it clear that if they're there and they're willing to serve, that they can, and, serve that office, but there is not a requirement that they have to serve. Questions, comments on that?
I thought your change was a good one, Chair.
Do you understand when I'm asking for a committee amendment? Because you get to ask for it as part of your training. All right, so you take the bill as amended by the House. All right, go to line 5. Got to educate them well. And the committee amendment, as I proposed it, would take out the deletion of and until a successor is appointed and qualified. And insert in between and until may serve. So the sentence would read, or starting at line 5, of employment and may serve until the successor is appointed and qualified. Okay? This is good training for you. All right, so I will move the original bill,
Second.
seconded by Senator Susi. And I will move the committee amendment,
Second.
seconded by Senator Susi. Further discussion on 72? All those in favor of the amendment, say aye.
Aye.
Opposed? Seeing no opposed, all those, is there any discussion on the bill as amended? Seeing none, all those in favor of the bill as amended, say aye.
Aye.
Opposed? Do I have a motion for consent? Senator Susi.
Second.
Seconded by everybody. Senator Perkins Cuoco seconded.
Sure.
And all those in favor of consent say aye.
Aye.
And it will be on the consent calendar.
Who is taking it out?
I'll take it out since I did the amendment.
Amended it, okay.
All right. In the emails that you guys have gotten, House Bill 75, House Bill 83, and House Bill 87 all came out of the same committee, all by the same sponsor. And in case the House does not send over a budget, this would allow me, if I take and combine all of those into one bill, which would be 83, and the amendment, if you don't have it with you, was distributed. If not, there are up on the table. So on House Bill 83, I'll open the executive session on that and entertain a motion of ought to pass if we have one.
So moved.
Senator Perkins Coca moves ought to pass, and seconded by Senator Susi. Do I have a motion on amendment 2023 10066S? And Senator Murphy, seconded by Senator Susi, moves the amendment. Doesn't do anything except take and put those three bills together. The chair of finance asked me to make sure he had a couple of bills that he could do things with if he needed to for a budget.
Say no to him.
I don't normally. So, is there any further discussion on the amendment? Seeing none, all those in favor of the amendment say aye.
Aye.
All those opposed? And now for the bill as amendment. We've got to do the bill as amended first. I try to rush it too, but I know. All right, ought to pass as amended. All those in favor say aye. Aye. Okay. And Senator Susi moved consent. And I'll second it. All those in favor of consent say aye.
Aye.
And that's 5-0, and I'll take that one out also, since I'm the one that's pushing that. So right now, 75 and 87 will sit there for a while, and we will talk to the Senate clerk about moving them to finance or just leaving them here and sending them on as we go. And I think that's,
Come out of executive session.
we have a motion to come out of executive session. All those in favor say aye. Aye. All those opposed. And our business of the day being completed, we are adjourned.